Hello, this is Professor James Strickler, and this is a course in American government. This lesson is from Unit 7 about the judicial branch. It's Lesson 8 about the United States Supreme Court. In this lesson, you'll learn about the Chief Justice of the United States Supreme Court, about the Associate Justices of the Court, about swing justices, about the appointments and terms of the justices, about law clerks, and about the jurisdiction of the Supreme Court. In the previous lesson, we learned about the structure of the American judicial system. How, in a sense, we actually have two judicial systems. We have the judicial system of the United States of America, and the states have their own judicial systems. I guess in a way you could say we have 51 judicial systems. We learned that at the very top of all this structure is the United States Supreme Court that has authority over all these cases taking place underneath them in the federal court system, and potentially has authority over state court decisions also if they raise federal questions. So now let's begin our more detailed examination of the way our American court system works by looking in detail at the United States Supreme Court. We'll begin that more detailed analysis by first examining who works at the Supreme Court. Here's a most recent photo of the entire United States Supreme Court. Now, it's been a while since a photo was taken because one of these justices in this photo is actually now deceased. On the front row, the second from the left, is a man named Antonin Scalia. He is no longer on the Supreme Court, but as of the time of this recording, he has not yet been replaced. So normally the Supreme Court has 9 members, but right now it's operating with just 8. The other thing that you should notice about this photograph is that the person seated in the middle is the Chief Justice of the United States Supreme Court. We're going to talk a little bit more about him now. The Chief Justice is a man named John Roberts, who was born in 1955 and appointed in 2005 at the age of 50. Now that's fairly young for someone to begin serving on the United States Supreme Court. Maybe I shouldn't say that. Most of the time when people are appointed to the Supreme Court, the president's kind of shooting for someone, at least in that general age range, because he wants to have somebody around in the court for a while to influence it. But he's still probably younger than most. Now, there's something to notice about that, though. A fairly young person being appointed to the Supreme Court to serve as Chief Justice. The office of Chief Justice is a completely separate one from the rest of the court. A person does not sort of work their way up to Chief Justice by serving on the court longer than anybody else. When a Chief Justice retires or dies, the president, in the case of John Roberts, George W. Bush, simply picks the person who he thinks is best for that position and appoints them whether they're on the court or not. The Chief Justice of the Supreme Court is sometimes described as the first among equals, as the person using that description is trying to explain the role of the Chief Justice on the court. What is meant by him being the first among equals is that he's the administrative leader of the court. That's how he's first. For example, in their private meetings as justices, he gets to speak first if he wants to. When they meet as a court, he presides over those meetings, that kind of thing. He even manages the details of day-to-day life at the court, such as assigning people office space and things like that. So in that sense, he is the first. He's in charge. He's the leader of the court. But when it comes right down to the most important business of the court, his vote counts the same as every other justice. So in a Supreme Court of 9 justices, when a decision is being made and they vote, he could be one of the justices on the losing side. Let's imagine it's a 5-4 vote and he's with the 4 that are voting together. He loses. And he cannot then sway the vote his way by somehow doubling his vote or taking a vote from somebody else or not allowing them to vote. No. Everybody's votes are equal on the court. So he is the leader, but he is equal to all the others. Let's go back to our photograph. So we have the Chief Justice sitting there in the middle. We've already talked about him. Now let's sort of set him aside and notice that there's 8 other justices in the photograph. Those 8 other justices are referred to as associate justices. Now let me tell you a few of the characteristics of them. Here we have the 8 current members of the United States Supreme Court listed out. Now notice I have a vacant spot at the bottom for the one spot that's open on the court because of the death of Antonin Scalia. The thing to notice about this diagram right now, or I should say this list, is the ages of the justices. I'll explain more about what the other things on it mean in a few moments. But for right now, notice the years that they were born. Ruth Bader Ginsburg, the third one down the list, is, at the time of this recording, 83 years old. Anthony Kennedy, the one at the top of the list, is 80 years old. Stephen Breyer, fourth one down, is 78 years old. There are some very old people on the court. Now, why would they be so old? Well, it has to do with the appointment process and the terms that they're allowed to serve under the Constitution, and then what they choose to do with those possibilities. United States Supreme Court justices are appointed by the President and then confirmed by the United States Senate. But the Supreme Court says that once they're there, they will hold their offices during good behavior. There's only been one attempt in our country's history to kick a Supreme Court justice off of the court. And in that one try, the United States Congress failed to do so. So, being told in the Constitution, if you're appointed to the Supreme Court, that you have your job as long as you behave well, essentially amounts to a lifetime appointment on the court. Now, I say essentially because it's not like they're required to serve for life. A justice can quit the court anytime they want, and about half the justices do retire before they actually die. But the other half keep serving in their position as Chief Justices up until the moment of their death. Let's go back to our list, because I want to point out one other thing about it now. Notice that it's color-coded. There are 4 justices that are in blue. There are 3 that are in red. The vacant spot that used to be held by Antonin Scalia, if he was still there, he'd be in red also. Those blue and red colors represent not just who appointed these people, but their ideological disposition. The presidents listed in blue that made the appointments, President Obama and President Clinton, were Democratic presidents, and they appointed liberal justices. Now, you won't know quite yet what that term liberal really means in the context of the Supreme Court. But from earlier lessons in this course, you should understand at least a little bit about it. These are people who believe in the intervention of government, sort of big government to make things more fair and equal in people's lives. The other justices listed in red were appointed by Republican presidents. Bush 41 refers to the first George Bush who was president of the United States. He was the 41st president. Bush 43 refers to the second George Bush who was president of the United States. He was the 43rd president. And these Republican presidents appointed justices to the Supreme Court who are generally conservative. That means, remember, the basic idea of conservatism is wanting to keep things that work well the way they are. Not be too experimental, don't take too many chances, don't throw the baby out with the bathwaters, as we explained earlier in the course. Now, if Antonin Scalia was still on the court, you would have 4 liberals and 4 conservatives. And then we got this one justice there in purple, Anthony Kennedy. Anthony Kennedy is in purple because sometimes he sides with the liberals, sometimes he sides with the conservatives. In a sense, he was a mistake made by President Ronald Reagan, who was a Republican. When he appointed Anthony Kennedy, he had hoped that he'd be a solid conservative, but he ended up going both ways. Because he may vote with either liberals or conservatives, Anthony Kennedy is described as a swing justice. Oftentimes the court will have somebody on it who's a swing justice, the person who's kind of in the middle, that really decides who wins. Because he's the man in the middle that really decides who wins, arguably, this swing justice is the most powerful member of the United States Supreme Court. In addition to the United States Supreme Court justices, there's a team of law clerks that work for them. Each justice has a group of 2, 3, or 4 of these clerks. Here's a photograph of 2 United States Supreme Court justices, the 2 people in the middle. Ruth Bader Ginsburg on the left and Antonin Scalia on the right, although you don't need to remember that, with their law clerks that they had working with them during that term. It looks like Ginsburg had 4 and Scalia had 3, but the numbers can vary. There's 3 characteristics of these law clerks for you to know. The first is that they are recent law school graduates. Usually they graduated just a year or 2 before they get a job at the United States Supreme Court. They are usually the elite law school students in the country, people who graduate near the tops of their classes at the best law schools like Harvard and Yale. When they get hired on the Supreme Court, it's to help the justices do research. They're the ones who will read the petitions where people are asking to have their case heard by the Supreme Court and summarize them for the justices. They are the ones that will then go research laws in previous cases when the justices have to make a decision. Things like that. They also will assist justices oftentimes with the actual writing of their opinions. When a case is decided, one of the justices has to write an explanation. They will often assign their clerks the responsibility of writing the first draft of those opinions. So by the clerks doing the research and at least a portion of the writing, they can have a powerful influence on the decision that the justices actually make. So what does the Supreme Court do? Well, we can only begin to get into it in this lesson, but we can at least cover the basic jurisdiction of the court. In a previous lesson, you learned about the idea of original jurisdiction. Original jurisdiction was the kind of authority that a court has to hear a case at the trial level. A court of original jurisdiction hears trials. That's where the cases originally begin in the court system. And those trials are primarily concerned with questions of facts. What actually happened? Well, the Supreme Court actually is assigned by the Constitution to have original jurisdiction, but in a very limited number of cases. For example, cases involving ambassadors or involving a state, that kind of thing. Now, those sorts of cases that come to the Supreme Court are fairly rare. They only get a couple of them each year. And the way they actually handle those cases, since they don't have time to really do a trial themselves, is they borrow some other judge and assign him the job of supervising the trial, and it goes through the whole trial, and then that judge will turn the record of everything that happened in the trial over to the Supreme Court. They'll read through it and then essentially act like a jury and decide who wins or loses. The Supreme Court has this original jurisdiction where they can act as a trial court, but it's used in only a small number of cases. The other kind of jurisdiction that you learned about previously was what we call appellate jurisdiction. This is where appeals are made up to these higher courts above the trial courts, and these appeals primarily concern questions of law. Was the law correctly applied in the decision that the trial court made? This is where most of the Supreme Court's caseload comes from. The Constitution says that the Supreme Court will have appellate jurisdiction in all those sorts of federal question cases that we've mentioned before, with such exceptions as Congress will make. In other words, Congress can take out some of these cases that the Supreme Court would normally hear and say, no, you're not allowed to hear that case. This is something that Congress very rarely does. So in a general sense, the Supreme Court can pretty much hear any appeal they want, as long as it involves a federal question in some way. So now let's review what you learned in this lesson. How is the Chief Justice equal to the other justices? Is it that he gets to speak for the same amount of time as them? Is it that his vote counts the same as theirs? Is it that he's paid the same as them? Or is that because cases are randomly assigned to different justices? He is the same as the other justices because his vote counts the same as them. I should say he's not the same, he's equal to them because his vote counts the same. How many associate justices serve on the Supreme Court? Is it 7? Is it 8? Is it 9? Is it 10? 8 associate justices serve on the court. Now this is potentially a tricky thing because there are 9 justices on the court, but one of them is the Chief Justice and the other 8 are associate justices. What is a swing justice? Is it a justice that works part-time? A justice that may vote with either side in a case. Is it a judge that's disrespected by the clerks? Or is it an underqualified justice? A swing justice is a justice that may vote with either side in a case, and thus probably has great power over what the outcome will actually be. How long is the term of a justice? Does the justice serve for 10 years, or 20 years, or 30 years, or in good behavior? According to the Constitution, a justice serves in good behavior, which ends up being, as a practical matter, a lifetime appointment. Of course, the justice can leave before their life is actually over, and about half do, but they can stay there till they die if they want. Who assists justices with research? Is it the Library of Congress? Is it the reporters in the press gallery? Is it law clerks, or is it the Attorney General of the United States? The justices are assisted in their research by their teams of law clerks that they hire. What type of jurisdiction does the Supreme Court have? Do they have original jurisdiction, appellate jurisdiction? Do they have both kinds, or neither? The Supreme Court actually has both kinds of jurisdiction, but their original jurisdiction is limited to a very specific, small number of cases listed in the Constitution, and they only get a couple of those kind of cases each year. That completes this lesson. The next lesson will be from Unit 7. It'll be Lesson 9, about the Supreme Court accepting cases.